Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley, and this is I Now Pronounce You Divorced, Melone Hatley's podcast, where each week we come together and we talk about legal issues that we see our clients going through. Today I'm joined, as always, by Mr. Dan Cuneo and Mr. Peter Bradshaw, who is an attorney out of our Tampa, Florida office. One of the questions that we have been getting quite frequently, and it's not a surprise, right? School's just getting started back, but it is, what do I do when I don't yet have a custody order and I can't agree with the other parent on what to do? So, Peter, can you first kind of explain to us what is a custody order in Florida? What does it do? What does it say?
So I think the biggest difference here in Florida is that we don't use the word custody anymore. We got rid of that. We call it time sharing and parental responsibility. Time sharing is based on who has the child, like physical time with the child. And then parental responsibility is the ability for each party to make decisions about the minor child. So the quick answer is it depends, which is the typical attorney answer. But it also depends on which parent is asking for it. So let's say, for instance, you have parents who have been married and are now separated and they're having issues. That's a lot different than a situation where you have a woman, a presumptive father of a child, and there's no order, and they don't agree that he is the father of the child. And so that raises a lot of different questions. But the ultimate thing is, the first thing is, if you can, try and start a conversation. And the reason I say that is one of the first questions that comes up in Florida statutes with regards to what's in the best interest of minor children is looking at which parent is trying to be the most reasonable and cooperative with the other parent.
Yeah, in some of the states that I'm licensed in, they've changed the terminology too, and it can be bifurcated. You have the time and then you have the responsibility. In Florida, with the delegation of responsibilities, can those be bifurcated in the sense to where you can allocate X number of responsibilities to one parent and the remaining to the other? Or is it a 50-50 presumption and all or nothing? Can you kind of walk us through what that looks like?
So the two issues, parental responsibility and time sharing. So start with the parental responsibility. Who gets to make those decisions? Which school is the child going to go to? What kind of education they're going to come up in? That one, unless a party can show that there's detriment to the minor child, that's going to usually stay shared, meaning both parties have to confer, come to a joint decision. Time sharing, on the other hand, is a little more complicated. Florida starts at a place of equal time sharing, unless a party can show that it's not in the best interest of the minor child by what we call a preponderance of the evidence, which is honestly just fancy lawyer talk for, a little bit in your favor. And so, yes, it can be divided up, the time sharing. Yes, the parental responsibility can be divided up. But if you don't have an order in place, then assuming both parents are recognized as the parents, both are going to have the ability to make decisions. But the parent who starts making decisions without conferring with the other one, that's the one who's going to have issues when you get to court, because the courts are going to look at this parent and say, look, they're not trying to cooperate. So who's really trying to foster a relationship with the other parent?
I have to admit, I think it's kind of funny that Florida changed their terminology to be time sharing, like, oh, another timeshare in Florida. But, what do you tell somebody that comes in and talks to you? And we get these conversations all the time, right? The other parent and I, we're headed towards separation. And I'm just talking about the people where parentage is known, not in situations where parentage is unknown. But, the other parent and I, we just don't agree. I don't really want to do anything yet. I don't want to file anything yet. But what are my rights? So what are your rights if you haven't filed anything yet and there are no court orders?
So if you guys have already, if both parties have been married before, and both are recognized. Now, let me be clear about this. Florida actually changed its laws in the last couple of years so that fathers, as long as they are on the birth certificate, have been on there for a little while, let's say the child's a little older at this point, nobody's contesting parentage, they have more rights now. Because previously, it was only determined that the mom had the rights. Okay, so that's changed in the recent years. So now that fathers have rights, what I will always tell somebody is be the adult in the situation. And that means even if the other side is a complete jerk to deal with, you have to keep yourself together. And if they are being a jerk, I recommend documenting as much things as possible. Let's say they're not keeping up with their time sharing. Keep it. If they're texting you terrible things, keep it. Try not to have conversations over the telephone. Try and do it email, text message, something where you can easily, or at least more easily, provide that stuff. But it's hard. I mean, look, divorce is hard already, but when you start throwing kids in there and people having disagreements and one party even like using the kids against the other, I mean, that gets really difficult. And there is no easy answer. Like, we as the attorneys don't have to live in the specific moments that our clients have to live with in. But what we can do is try and make the rest of the stuff, the complicated stuff, a lot more easier by explaining it and providing that information and talking them through it. And sometimes even just being the counselor that they can talk to and say, look, he's being completely unreasonable. You're my attorney, fight for me. And I'm like, yes, we'll fight for you, but we got to get to that point. Right? There's things that have to happen procedurally so that we can get to that fight, so that we can make sure that your rights are followed, and so that, the you're protected when you get to court and they can't say, well, she didn't do X, Y, and Z, or he didn't do X, Y, and Z. You're like, no, we took care of all those steps. Now we're ready to fight. Let's go. And I had a great experience with that almost a week or so ago. Klein and I have been working for almost a year and a half on trying to get the case done. He finally got to see us as litigation attorneys in court fighting for him. And that was a really positive experience in my sense, because, you could see a substantial difference between our attorneys and others.
How much weight does a judge give when you're saying document when a client comes in? Because and speaking with our sales team, that our client service coordinators and whoever kind of field the first calls, we have clients who call in and say, I can't see my kid. Do I need to file something now? I mean, is that the time to, or is it, do you have to document and then wait? And to me, just from my prior experience in meeting with potential clients and when I really would heavily litigate, that was always kind of the frustration on some clients is, I can't see my kid, we need to file right away. But I know in experience, or prior experience, I should say, that judges don't like you using the court as a weapon right away. They want to try to see you work it out. But on the client side, to what you're saying, it's frustrating, and I can't see my child or my children. This isn't fair. How do you handle those, and how do the courts in Florida handle those?
So let's start from this is a multi-tier question, by the way. So thanks, Dan. So let's go with the easiest situation. Nothing's been filed yet. Nobody's started anything. And somebody's trying to make the decision to file or not. My answer is always file. And the reason I'm going to say that is because once you filed, the other side's been put on notice. Hey, here are the things you need to do in this case. And what's nice is in Hillsborough County, where we're normally located here in downtown Tampa, Hillsborough County has what's called a standing order in family law cases. And it also has some rules of civility. And those things are filed and provided to the other side. And it says, hey, these are the basic ground rules. And in my opinion, I think the courts look at, once a party has filed something, once those rules have been put in place, the court is going to give the actions that occur after that a little more scrutiny. Okay? Now, let's say you don't know whether or not you want to file or not, and you're trying to play nice and whatnot. There is nothing wrong with filing a case. And the only time I would say that that's any difference is maybe if you're living together still. That's some problems. But the thing about filing a case is that it doesn't say we're fighting each other. It doesn't have to say that. It says, this is what I want out of this process. Okay? And one of the things that I always try and tell people is, especially if they're respondents for a case, meaning they've been served with pleadings, is, look, this is what they want out of the case. They have to request everything. Like, here's a good example. They have to request attorney's fees, okay? Because otherwise they're not entitled to them. So this is a process. This is saying, hey, this is what I want. This is not necessarily something where we have to burn everything down. Because honestly, I try and talk people into saying, like, look, you guys are going to have to be parents for, 18 years of the child's life. but then you're also going to have grandkids and all kinds of other things that cross over. So, you guys can litigate issues, and that can be fine. We can disagree. We can respectfully disagree. We can go to court and say, this person did this and this person did this. But at the end of the day, you both have to say, look, we've both presented our cases. This is what the court said. We still have to work together. And so that's always a tough line, too, because feelings get hurt.
They do. And I mean, I can tell you, I was thinking about a case I had that was in between Virginia and Florida. And the child was in a very bad situation in Florida. My client had called me. He's like, what do I do? I was like, just go get your, there was no orders. I was like, just go get your kid out of that situation. Shows up in Virginia. We filed the next day. And there was no question that jurisdiction was at issue, but we won. And jurisdiction stayed in Virginia because the Florida court just gave it up. And the Florida attorney for the mother filed appeal. We went at the appeal level, filed appeal to the Supreme Court, wanted that because the Florida judge gave it up. And in all that time, we were able to move forward on our case. And we got the kid out of Florida, which in this particular situation was, I mean, the mom was living in a flop house. So there was a lot of drugs around this child. And
Right.
now the mom, but it got that bad.
And Charles, you're absolutely right. I mean, jurisdiction can often be an issue, especially when there's emergency situations. And Florida has very specific case law with regards to what is and is not an emergency. And so, person A took the child for the week when it should have been my week. That's not going to usually be considered an emergency. But Florida statute 61.13, it's our main time-sharing statute, does have remedies built into that, including, penalizing the other side, forcing them to do community service, giving make-up time sharing. So there are options available as well. But it sounds like the situation you're talking about is like an emergency jurisdiction situation. And that's especially prevalent when you've got issues of domestic violence, child abuse, or child abandonment or neglect.
Well, ours was, I mean, literally, if mom had filed first in Florida, we would have had a tough case. But dad filed first in Virginia. And that's I always tell people, look, that's what you're running the risk of, right? You're running the risk that somebody's going to move faster than you. And you're running the risk that maybe you don't even agree with the court's decision, but it's the court's decision now.
How do courts in Florida handle the terminology joint custody? Does that mean 50-50? Because we also have a lot of potential clients who call in and they don't really know the terminology. They say, I want joint custody. And then through meeting with the clients, you have to kind of flesh out what that means to them. But what's the proper way to address that in Florida?
The quick answer is we translate it to Florida, basically saying shared parental responsibility and some sort of time sharing where both of you have time sharing. Now, somebody can have majority time sharing, meaning like they have more than 50% of the time. I mean, but I don't think, most courts, if we see like a joint custody, like say, hey, both parents have joint custody, then I think most people would interpret that as joint decision making or shared parental responsibility, as well as shared time sharing. And then if we start running into problems with, somebody's not actually following time sharing or not providing it, or not enabling it to happen, then we have to get the court involved.
And how does that affect child support calculations?
So my punchline and the way I like to put it is child support is less of a law issue and more of a math issue, at least in Florida. And child support is the main two factors are the gross incomes of each of the parties and the amount of time sharing that each party has. There's a number of other little caveats that can come into that, including like medical care and who's paying for daycare or child care. But generally speaking, if one party has more time sharing, then they're going to likely need to provide more support for the child, or they're going to have more support for the child. So I usually try and explain with like 3 instances. So let's say both parties have equal time sharing, equal incomes. It's unlikely anybody's going to pay support to each other. Let's say one parent has more time sharing and they have equal incomes. So more time sharing, but equal incomes. Then, the party who has less time sharing is going to have to pay. Kids need to be entertained. They have to have food, clothing, shelter. So if the other side has the child more, obviously they're going to need some help with that. And lastly, let's say one party makes way more money, but there's equal time sharing. Then the party making more money is going to have to pay the other parent. And that's because in Florida, in Florida, child support is not your right as a parent to give or receive. It is the child's right to be fully supported by both parents, even when they're not with the other parent. And that's one of the things that is hard to get through to some people who say, well, I want 50-50. And I'm like, do you actually, or do you want to just pay less? Because that doesn't necessarily fix the issue if you're making way more money.
Have the courts, and I know in certain courts in Virginia where there's higher earning people, the courts are willing to entertain different types of child support. And what I mean by that is, you have one parent that's about to get a $20,000 a month check. And at no point in time have these people spent $20,000 a month on this child. Will the courts entertain that type of logic, or is it just straight, nope, that's what the math says and that's what the other side's going to get?
So there's a couple of things I want to pick apart in that question. So first of all, they have to base it on what the income is at the time we're making that calculation. Okay. So if the person is going to theoretically get a check at some point in the future, then no, that's not going to happen. You're going to have to come back for modification later on. If they're getting the check currently, the 20,000 or whatever, then the court has to abide by the guidelines in the Florida statutes. But they are allowed to make deviations based on what is in the best interest of the minor child. And there has to be written findings as to why they are deviating from those guidelines. And that's whether they're deviating upwards or downwards. So without those written findings, you're going to have a deficient order at that point and possibly be subject to appeal.
When you're talking about the child support guidelines, and it's a mathematical problem, which I think is similar across a lot of other states. But if you, I guess, two-part question. One is, if you have a client who comes in with a court order using the calculations for child support, what is the process to modify that? And is it different if you have clients that come in and they have a settlement agreement and they agree to a child support number? Is that the ability to modify that? Are the guidelines, is it different, or do you just still apply the same type of strategy behind it?
Well, and this is where it is case by case, and this is why it's good to have an attorney look at those things. Because if it's based upon the fact that, let's say, maybe one party isn't actually exercising their time sharing, then now you have an issue where you need to modify the child support because the time sharing is massively different. If you've got it where maybe somebody's income has changed, that's a completely different situation. And so the answer is it kind of depends, but usually it would be something as like a petition to modify, whether it's child support or, even the whole thing, the whole order. When it comes to a settlement agreement, if there's a substantial change in circumstances, then there may be some basis to modify child support at that point. Okay. Usually courts are going to respect agreements between parties. It also may depend on how much time has been in between that, or if maybe there's something deficient about that agreement too. So it can get into the weeds, and this is why it's good to have an attorney to talk to about those things, because there are those many details that you want to try and issue spot, and it's important to be able to sit down and have a conversation, and so that somebody can ask you those questions, because most people don't know what they don't know. Like, they're not sure about what circumstances will cause that, and it's not always just, hey, person A makes more money than me.
Peter, I want to thank you for joining us for part one, discussing Florida rules when there isn't a custody order. And I want to, next week what we're going to talk about is what happens when there is a custody visitation order or a child support order and the other side's not following it. What do you do then? So if you or someone is going through a family law issue or custody and visitation issue, give Melone and Dan PC a call and see the difference that a partner can make for you.
Thank you for joining us this week on I Now Pronounce You Divorce. Please join us next week for